Welcome to the IPC's webinar on how records and information management can help institutions comply with Ontario's access and privacy laws. Today, we'll be discussing records and information management best practices that can help your institution improve its ability to respond to access requests and protect personal information. Since the IPC opened its doors over 30 years ago, our office has seen a steady increase in the number of access requests and appeals filed from across Ontario. In the last decade alone, we have seen the total number of access requests under both FIPA and MFIPA grow from over 36,000 in 2006 to close to 62,000 in 2016. Our number of appeals have also nearly doubled, from under 900 in 2006 to over 1,500 in 2016. This growth will not surprise anyone processing access requests in institutions, but it illustrates an important fact. Numbers of requests are growing with no indication that they will slow down anytime soon. This is why the IPC has prepared this webinar. Institutions need to be prepared to effectively respond to access requests, and strong records and information management can help. So why is good records management essential to access and privacy? Simply put, effective management of your records improves your ability to respond to access requests in a timely manner, reduces your costs and those of your requester by making searches more efficient, reduces the risks of a privacy breach, and builds public confidence in government institutions. Strong records management is also key for implementing open government. Properly storing and classifying information can help facilitate proactive disclosure, while preventing accidental publication of confidential information. Let's begin our discussion with some of the challenges caused by poor records management, starting with excessive fees. We know that if records aren't managed well, they can be difficult to find. When access requests are received, poorly organized records can result in higher costs for both the requester and your organization. That being said, institutions cannot expect to offset the costs associated with poor records management onto access requesters. If an individual believes that an access fee is excessive, they can file an appeal with our office and we may order the fee reduced. One such example is Order PO 3035. In this case, McMaster University received an access request for travel expense records. The university estimated a fee of more than $1,000. They claimed that because the records were intermingled and difficult to find, they required more time than usual to collect and provide the records to the requester. The fee was appealed to our office, and our adjudicator decided that the requester shouldn't bear financial responsibility for the university's poor records management practices. The fee was ultimately reduced to $120. Retention schedules are policies that set the rules for how long records must be kept and whether they are to be destroyed or archived after that time has passed. When organizations fail to implement or follow retention requirements, they put themselves at significant risk. Records may be inappropriately destroyed or lost, which not only makes it impossible to meet your access obligations, but it can also be a violation under FIPA, MFIPA, or the Archives and Record-Keeping Act. From a practical side, failing to destroy unneeded records in accordance with their retention schedule means that all of those records remain available for request under FIPA or MFIPA. Keeping all of those records can mean significantly greater workload when responding to access requests. Institutions cannot be transparent and accountable if they fail to maintain their records, and this directly impacts the public's trust and confidence. Poor records management can even have consequences for staff. In 2013, we received a complaint that the chief of staff of a former Minister of Energy inappropriately deleted all his emails related to the cancellation and relocation of gas plants in Oakville and Mississauga. Our investigation found that this was in violation of the Archives and Record-Keeping Act and the record retention schedules for ministers' offices developed by the Archives of Ontario. By violating the Act and records retention policy, the Chief of Staff had also undermined Ontario's access and privacy laws and the very principles of transparent and accountable government. In 2015, 2 Premier's office staff members were charged with criminal offenses in relation to the deletion of gas plant emails. In our report on the gas plant email scandal, Deleting Accountability, we issued a number of recommendations to the Office of the Premier and the Ministry of Government Services, including suggested amendments to FIPA and MFIPA. In 2015, both FIPA and MFIPA were amended to strengthen record-keeping requirements in response to our recommendations. These amendments require institutions to take reasonable measures to protect their records in accordance with the law, and also make it a punishable offense to alter, conceal, or destroy a record with the intention of denying access. Measures must be taken to protect records in keeping with the mandatory requirements. Policies are not enough. Your institution should implement ongoing and regular training, develop teaching tools, and do regular reviews and audits to ensure compliance and measure performance. There are times when business and policy decisions are made in meetings, over the phone, or in settings where records are not physically or automatically created. When these decisions and actions aren't recorded, organizations cannot be fully transparent or accountable, nor can they meet their obligations under access and privacy laws. The duty to document is a requirement to record an organization's business activities, including accurate records of key decisions, regardless of the communication tools used or the setting in which the information was conveyed. These records should be created and stored in formats that are in keeping with good records and information management practices. Our office recommends that organizations implement a comprehensive duty to document policy for business-related activities. You can begin by making sure that staff are trained and able to recognize what kinds of records need to be created and properly maintained. Creating templates can help a great deal by making it easier for staff to create records of decisions made in meetings, over the phone, or in hallway conversations. Raising awareness and conducting regular training on records and information management will encourage your staff to maintain compliance in the long term. Under FIPPA and MFIPPA, records are any documented information, no matter how recorded. As such, retention policies and access and privacy laws apply to all forms of records, including emails, instant messages, or any other media used to conduct public business, even if the account used to send the message or email is a personal rather than professional account. Institutions, public servants, and elected officials cannot evade access to information requests by using a personal email account. If staff of Ontario's institutions choose to use personal email or messaging tools to conduct public business, the records created using those tools are still subject to access requests. This was emphasized in Order MO 3281, where the City of Oshawa received a request for access to all communications between a councillor and an individual. The city denied access to the information, claiming that the records weren't in its custody or under its control because the email was sent from the councillor's personal email account. We found, however, that the records were directly related to city business. This meant that the city did, in fact, have control over the information, and we ordered the records to be released. Following the release of MO 3281, the IPC produced a guidance document on the use of personal email and instant messaging tools to conduct business. In this guidance, we emphasize that while these tools may be more efficient, they create a number of challenges for compliance with access and privacy laws. These include finding records for access requests, ensuring that records are retained and stored in compliance with access and privacy laws, and ensuring that personal information remains secure. Because of this, the IPC generally advises against the use of personal email accounts or instant messaging tools when conducting business. That being said, sometimes their use is unavoidable. In those cases, we strongly recommend that organizations implement appropriate policy and practices and plan for compliance with access and privacy laws. This involves assessing the risks and benefits of instant messaging and personal email, developing and implementing clear use policies for employees that outline what tools may be used and under what circumstances, as well as how to save records created using these tools to the corporate file management system. Providing clear training on these policies with regular reminders and refreshers, and monitoring staff use and regularly reviewing their practices. Now let's consider personal information. An effective records and information management system needs to include requirements for the secure storage and destruction of personal information. Personal information must always be protected from theft, loss, and accidental disclosure. It must also be destroyed in a way in which it can't be put back together to identify individuals. If you fail to follow secure storage and destruction practices, you are vulnerable to privacy breaches and may be in violation of Ontario's access and privacy laws. The issue of secure storage and destruction was addressed in the IPC's first order under the Personal Health Information Protection Act. The problem began when scrap paper meant for recycling was scattered around a street in downtown Toronto as part of a film shoot depicting a disaster. Our office was notified by a local reporter who discovered the papers were actually discarded medical records. Our investigation determined that the special effects company responsible for the scene had acquired the records from a recycling company, which in turn had acquired the records from a health clinic that had not properly tagged them for shredding, which resulted in the records being sent for regular recycling. This failure on the part of the health clinic to follow secure record storage and destruction procedures resulted in a major privacy breach. Let's turn our attention to some best practices you can implement to improve your ability to comply with access and privacy laws. Create a requirement for staff to document business-related activities, including a duty to accurately document all key decisions. Clearly define which communication tools and programs are authorized for use by staff. Use technologies and programs that automatically create a lasting record. Develop and implement record retention schedules and policies to avoid inappropriate destruction of records. Organize your records into functional file classifications and plans, rather than by organizational structure or the media used to record information. Organizational structures may change, but the core functions of organizations usually do not. Functional classifications will help future users quickly find relevant material. Plan for access, privacy, and security requirements throughout the entire life cycle of your records. Identify records containing personal information or other sensitive information and ensure that they are appropriately protected. Develop and use file naming conventions that improve searchability. The goal is to help users find information quickly and reduce the time and resources associated with access requests. Develop plans for ensuring that records are retained and secured when staff leave their positions. Make sure that records are moved from personal drives and email accounts to corporate storage. Train and support your staff. Offering regular training sessions and refreshers can help reinforce best practices. The success of a records and information management program is dependent on the participation of all staff. Include compliance as a performance measurement to encourage staff to adopt and stick with best practices. Regularly review and audit your organization for compliance. I'd like to conclude by emphasizing that implementing records and information management best practices like these are essential to compliance with your access, privacy, and open government obligations. Poor information management practices come with serious risks and can not only hinder your ability to meet your obligations, but can put you in violation of the law. For more information on access and privacy, including a number of publications on today's topic, visit our website, www.ipc.on.ca. Thank you for joining us today. We hope that you have found this presentation informative and helpful. The IPC is committed to working with Ontario's institutions, and we welcome you to contact us if you need assistance with today's subject matter or if you have any questions about access and privacy.